good morning, good evening, good afternoon, wherever in the world you might be. Today, we truly do have a global presentation for you. Today is, for me in California, it's September 20th. For Natalie in France, it's September 21st. And for Laura in Australia, it's September 21st. For Sarah in Canada, it is still September 20th. So we do a little going around the globe there. We're recording this in advance. The presentation here is September 30th that it will be airing. So against that backdrop, it's wonderful to be here. I'd like to introduce Laura Keily to you. She's the founder of Immediation, and she was the one who conceived and designed it. She's a Melbourne barrister. Coming to us from Melbourne, Australia this morning. And it's so wonderful to have you here. As you know, there is no charge for these programs. Every Thursday at 8 a.m. Pacific time, 11 a.m. Eastern time. And we welcome you to come. We just ask that you are generous enough to make a donation in any amount to a food bank of your choice or the one that has been proposed by the speaker. And so it's always a thrill to see how those numbers go up. Let me tell you a little bit about Laura for a minute first, and then we'll talk about her food bank, and then we'll launch into the program. The program itself is talking about tech for the modern mediator or arbitrator, the modern dispute resolutionist, if you will. And Laura, as I mentioned before, she's a barrister in Melbourne, Australia, and she, as she will tell us her reasons why, she conceived of a platform called Immediation. Am I pronouncing that correctly?
We call it Immediation, but a lot of people call it Mediation.
Okay. Well, Natalie can cut this out, so yeah, okay. She conceived and designed of a platform called Immediation, I-M-M-E, and then on with the mediation there. So I am Mediation. And it's used by barristers and others in Australia and New Zealand for mediations and for arbitrations. And it's a fascinating program. She's a leading, well, she's on the cutting edge of technology, and it'll be a pleasure to listen to her today and to have a conversation about different kinds of tech that those of us in the dispute resolution industry might be interested in, what we use day to day, and what else might be out there. So with that, Laura, your food bank is Second Bite, as I understand it. So Natalie will put the link to that in the chat. And Laura, why don't you go ahead and tell us about Second Bite, and then the floor is yours.
Thank you so much for having me. It's really exciting to be here. Second Bite is an Australian charity that I became aware of when they actually engaged my daughter's 4th grade class a couple of years ago in their mission. And the girls at that school were really helping raise money through creating crafts and things on their own. And I think they raised at that time about $300 as a 4th grade class. So it really brought it to mind for me when you asked about which would be my preferred charity. What they do in Australia is they work with the supermarkets and the large food chains to rescue the food that would otherwise go to waste and redistribute it to people in need, ranging from people, homeless people, Indigenous, all the way through to the rather large refugee population that we have here in Australia, and an increasing number of families in crisis as the socioeconomic divide continues to grow between rich and poor in Australia. I think it's an increasing need that they service. The other thing I really like about this charity is they're very conscious of the environmental impact that they are reducing by not having that food go to landfill. As we all know, that increases greenhouse gas emission. And one of the things that I'm particularly passionate about with Immediation as well is the ability to provide a green message to our industry. So that tied in nicely, I thought, in terms of their mission and ours as well.
Fantastic. Thank you.
Thank you so much.
So, Laura,
legal technology. Shall we, Natalie? Yes.
No, I'm fascinated by your software, and I know that you've partnered with Microsoft to develop this. But I'm curious, really curious, because, you know, as a business person, I always want to know what's the drive, what's the ambition, what made you want to do this? I want to know the backstory about what it is that encouraged you to devote years of your time and effort and money, your staff. You know, how did you make this happen, and why?
Thanks so much, Natalie. And it is, I guess, reflecting back, I am a product of my profession, and I have a lot to be thankful for in the way that I've been raised in the legal industry, and then in the dispute resolution industry, because it was that background, I guess, that led me to have the skill set that was required, I guess, in the ideation phase as well. So my background was predominantly mergers and acquisitions law. So I started as a corporate transactional lawyer in Melbourne, went to Slaughter and May in London, and loved that experience so much. And then I went to the bar quite late in my career, which is what happens in Australia, but it doesn't so much happen in other jurisdictions. So it's quite common for us to go and become a barrister when we have a particular specialisation. And so mine was corporate law and corporate finance. And so quite late in the day, I was 38 at the time, and I'd had my 2 children, and I just decided that law firm partnership wasn't for me. I had done over 50 large transactions and I loved them, but I was getting to the point where the intellectual stimulation coming from corporate law was sort of had evaporated, and I'd always had this long-held dream to go to the bar. And so I did. I decided that this was the time for what I thought was my last career change, and sat the bar exam and started at the bar, and it was fantastic. I did all the things. I was on my feet doing cross-examination. I like to tell this story that I went to some local regional courts and cross-examined a really big truck driver with tattoos all down his arms and made him cry, and won that case. So I did all the things that you do as a baby barrister. And I really, really loved that. And it was academic and intellectual and all the things I'd experienced in London. But there was this yawning sort of thing in the pit of my stomach, which was people kept saying to me, hang on a minute, you told me that there was justice. I thought that I would get a decent outcome, and I can't resolve this case. Or, you know, I've spent 3 years of my life doing this and it's ruined my whole life, and I've nothing. And this theme was coming up over and over again. And I had clients that I was lying awake all night thinking, how can I get them out of this? And often it was when they'd come to me late in the day, you know, wanting to appeal a decision, say in a lower court, that hadn't gone their way. But by that time they'd sunk so much in, and it was just impossible. And if you think about the cases, we've all done them. They're worth maybe $500,000, and they're everything to that person or business. And then each side has spent $200,000 on lawyers, and then they get to the resolution conference and no one's prepared to give in, because they say, well, how can I possibly pay out $450,000, for example, when I've already spent 200? And the person who's the plaintiff's going, but you've cost me 500 plus I've already spent 200. So there's no way I'm settling for 450. And this is what we do every day as resolution practitioners. But I guess coming in as a barrister quite late, I was seeing the train wrecks that emerged. And so I just felt compelled to try to do something. And it wouldn't leave me. And I think partly my background as a corporate lawyer had set me up for, I know how business works. I'd become a sole trader as a barrister, so I'd had some taste of the fact that I could do business development on my own, and it was okay, it was working. And so it just sparked in me when I heard of Colin Rule's success with Modria. Why isn't there something in corporate law to help people who have commercial disputes use technology to do this better and faster? So the original idea of Immediation was to let people go through a process online of exchanging documents and information with the other side that was very neutral and not aggressive. Because one of my observations was that often this terrible correspondence that gets written, which is, you know, pay me or else, and by the way, I hate you. And then the other side writes back and says, there's absolutely no way I'm paying you. I'll see you in court. That kind of correspondence, I was finding went against resolution. And so the platform was trying to bring the parties together and exchange the core bits of what they needed to know, but taking away the opportunity for all of that stuff around it. And then bringing the people together in a platform with highly experienced mediators, hopefully as early as possible. And so my theory was, for the same amount that it would take to open a file, why don't we try to give those people a pathway to meet a mediator who could probably, for the same cost as one lawyer's file, do the whole thing. And that was my original platform. And so I set about having discussions with my accountant, who said I was nuts about even wanting to go and build this thing. And I rang my super fund manager and said, can I have some money? I'd had a quote for $80,000 to build that platform. And he said, no, but I'd like to invest. And so I was sent on a journey of, okay, well, I've been offered investment. It's, you know, I'd been given 30,000 and I had to make up the 50, which I did. And then the defining moment was I went to a junior bar conference, and Michelle Gordon, who's one of my idols, a female High Court judge in Australia, one of the smartest women I've come across. And she said at this conference, you know, I wished I was 30 years younger so I could develop technology. And I just thought, okay, I want to be where you are, and you're telling me that you have some dreams that have never come to realize about being where I am, so I have to do this. And I took out my phone and paid the deposit in the conference, and then had another discussion with my accountant on the way back to Chambers to say I was doing it. And yeah, 4 years later, we've raised $10 million and built a very much broader platform and business, which is now launching in America. So I don't really know how to describe the last 4 years, but maybe we can get to that. It's been an amazing joy and whirlwind to be on this journey.
Well, and you know, not for nothing, but you've won more than a handful of tech awards for the program that you've designed for resolutionists all over the globe. So, you know, it's nice that you know the people in this room think highly of it, and you think highly of it. But obviously, it's really well done, because it's won 8 different tech awards. Is that right?
I think so. I mean, I have to say that I am very lucky to have an amazing team, and they do stand behind me, from engineers all the way through to lawyers. And that's the nicest thing about this journey, is to bring together the different skill sets which are required. And one of our theories is that you can't really build technology for the legal profession or for the resolution profession without actually knowing what you're talking about, because it's not fit for purpose. And so we have such a joyous relationship between the lawyers on the team and the engineers, where they're really educating each other on the different aspects of how to build technology. And I think that's probably what's reflected in these awards, as well as being, you know, at the beginning, I think people thought I was a heretic or just crazy, or why would you talk about using technology in mediation? This is 4 years ago, obviously, when, you know, it was not the done thing. And so part of the reason I'm proud of those awards is because I weathered the storm of, you know, all of the people who thought that this was never going to happen. And, you know, there were also the people who really celebrated it, and very senior members of the profession early on. But there were plenty of people who just said, oh, that's never going to take off. And, you know, how dare you suggest that something like this is possible? So it is sort of, I guess, a source of pride to think that we're at this stage. And I guess to just join those dots, what we ended up building was a video conference-based platform, which predated all of these other platforms that have now come about, which was designed purely to enable mediators to conduct a resolution online and have all the tools that they needed. And so what we then learnt in 2020 was actually that platform that we built for our own use case with our own panel members could be utilised by many others. And so we set about trying to provide it more broadly to a different audience, so that it wasn't just sort of kept for us and our work, but all mediators and arbitrators could use it. And that way the access to justice impact, I guess, is a broader one. We're not just helping those end clients that we manage to attract, but also improving the general state of affairs across the industry. And so it's that kind of rising tide lifts all boats mantra, that if we can get better technology in the hands of the courts and the mediators and everyone who's doing the work, hopefully we can shorten the time frame of people's disputes. And I think we're all in this industry because ultimately we want there to be fewer disputes and shorter and have less impact. So that's where we are now, is trying to provide that subscription technology on a much bigger scale.
And I would say, you know, it was a conversation prior to the COVID pandemic that, you know, has turned everything sort of topsy-turvy. When people would have said, well, yeah, the technology, we could use it, but, you know, what we do as mediators or arbitrators is a very human, it's a very interpersonal business thing that we do. And we are nervous that the technology will create a barrier between us and our clients and the parties. And I think now that after the pandemic has, well, I don't know if we were really encouraged or simply forced to pivot to technology, but now we're all very comfortable with it, I think, and understand that it does have great benefit. So that a program like yours now that truly does address the human issues, I think is very timely and very well received. And I think that your point to access for justice is really important, because it opens up areas. And this is a problem in Canada, for instance, when there are so many very rural environments and it's just too expensive, too time consumptive, just too much to expect for people to come into an urban environment to settle, you know, what might be a small claims case. The same in Africa. We just don't have those kinds of programs available for so many people globally. But using this kind of technology or your kind of technology or just sort of tech in general makes that access to our services possible.
It's really interesting. We just ran a program in the Northern Territory of Australia. So if you imagine if you don't know anything about Australia, a very wild landscape, it's the Crocodile Dundee type landscape. That's very cliched, but we just ran a program with the Northern Territory courts to actually enable vulnerable witnesses in the Indigenous community to participate in court hearings. And the prosecutors were saying to us, this is unbelievable because, you know, normally we don't have the witnesses there, so we can't win the case, but all of a sudden we've enabled that access for these people to participate. And it totally changed the dynamic, even in that short pilot, of their ability to win, which in that case, the police prosecution, so it's very different to the kinds of commercial cases we all deal with. But the point remains that there are areas of our society that are left behind in all walks of life, whether it's food security or whether it's access to justice. And so you probably can gather in me, there's a bit of a sort of left-wing sort of background. And, you know, I've been raised by teachers who always taught me to look to level the playing field for people. And so there's a bit of that comes through in this technology, that we're trying to remove that power disparity. People can really join in. The one place we don't remove the power disparity, I will say, is in the court proceeding itself. The technology very much enables the judge or the mediator or arbitrator to be in total control of the proceeding and not on an even playing field. So that's a bit of an exception to the rule, but you understand what I'm saying, that the system needs to enable everyone. But then when you're there, we need to replicate what happens in face-to-face proceedings to uphold the rule of law. And that's something that's really important. We've seen so many examples. I mean, the poor guy in the cat video, I don't know who he is, but I hope it's not the defining moment of his career, but that kind of thing cannot be allowed to happen because it undermines the rule of law, and that's the ultimate disaster. So we try to make sure that with technology, we emulate what the state requires to be able to enforce those things that it's always enforced in terms of security and privacy and the seriousness of proceedings. And even in mediation, it's very important that the mediator maintains that ability to control the room. And maybe when they take out that body language element that you're talking about, the human aspect, being able to use their body and their eyes and their face to kind of control a room or manage a room we need to give them the technological tools to supplement that when they're not in a physical environment. So we're very conscious of that.
Right.
Actually, I was just going to say, Natalie, I wrote a paper in 2019 about trust and the psychological impact of being online. And there is a whole lot of research about, you know, the trust aspects that are taken away when you can't use all of your 5 senses. So we need to try to, it was published in the Arbitrator and Mediator, which is the Resolution Institute's journal, but we need to supplement for that because you're taking away some of people's senses. So we need to kind of go the other way in terms of trying to enable the mediators to increase the trust that people have in them, to kind of try to counteract the benefits of being online, if that makes sense.
I think it does. And I think I'd like to include Jean in this conversation because Jean Lawler she's done hundreds of online mediations. So she knows firsthand what it takes to have the right kind of technology for her office, the backstage end of things, but then also the client-facing and the party-facing technology so that people are comfortable, so that they're okay, so that they are encouraged to participate, so that they have some sense of, oh, this person, they really can hear me, they really can see me, they really do understand my situation, and they still have that same sense of designing their own destiny, which is so valuable in mediation. So if it's all right, Jean, would you comment a little bit about your interactions with technology, and it's a good thing, it's a bad thing, and what's best use practice for our industry in using these kinds of technologies?
Sure. I loved it, Laura, when you were talking about 4 years ago or so, and I was thinking back while you were talking, that would have been 2017. And
right.
It was 2017 when I became a full-time mediator. I practiced law for 37 years before that, but I've always been very high tech, the one at the law firm who was in charge of the technology and this, that, and the other things. So an early embracer. And in 2017, I looked high and low. And again, you know, now the online mediations weren't necessarily a common thing. I wasn't thinking of that at the time until 2019, but looking high and low for programs or platforms that could benefit mediators and that would be easy, from the case management aspect to the rest of it. And you're right, there was nothing. The best one I found that I thought was something out of England, out of London, but, well, it wasn't London, but England. And anyway, I didn't go down that road, but your timing was probably perfect. I ended up creating my own whole set of everything. And you know, this here in the States, mostly, I think mediators by and large, for the most part, embrace Zoom. It was the easy one early on, you know, we're flipping to it quickly. And I personally had first trained on it at the end of 2019, certainly not thinking of a pandemic, but so that people in other parts of the world, whether they were the insurance professionals or lawyers that were across the country or in London or wherever, could participate, not just by phone, but you know, by video. And so one of the things that I would love to hear, I'm so fascinated by your program and I'm ready to make the jump, but what is it, how have people reacted to yours compared to Zoom, for example, just because that is what people use? I mean, how has the transition been?
Well, I guess ours is very different because it's, we try to make the technology disappear for the mediator, for the lawyer, so that they're actually in an immersive experience that replicates what they normally do, and they don't have to do anything to make it work for their environment. So one of the ways we do that, for example, is we set up the platform by client lawyer team. And so it knows, for example, if you've got more than one plaintiff and more than one defendant, and you can easily move people around with one click between those pre-designed teams. But the team members can also, by design, have private conversations among themselves and then come back to the main room and have team chat among themselves and then come back to the main room. So it's by design just doing all the things that you may have to kind of reorganize if you were kind of trying to do it on a standard video conference. And then we sort of move to things such as you can upload the documents in advance. Mm-hmm. You can share them among your team or with the mediator. And then you get to co-drafting tools where the settlement deeds are embedded into the platform and enabling faster. That's where the immediate mediation originally came from. Was, well, if you get to the end and it's midnight and, so sorry, Natalie, it's 2 a.m. for you now, but almost 3, you know, you just want to get the thing done. So what we need to do is simplify the process. So we have embedded documents in the platform where you just enter the settlement sum and the party's name and number, and you can pass the pen between the different lawyers, and you can take comfort in the fact that you know that you're not going to mess up something, and then you can have it signed on the spot. So it's sort of the ideation was taking the whole process and trying to streamline it to make it easier for the mediator to try to get to the resolution and have that resolution be sticky. So it's just a very different proposition. It's a video-based collaboration tool, but video is just one of the things. Yeah.
Well, and
so
having
really chalk and cheese, really.
And having that ability to have a settlement agreement, whether it's one that you've designed or one that is uploaded, presumably, you know, that the parties have provided ahead of time, and then to be able to fill it in and sign it pretty much on the spot. I think that is huge. And for people to feel that they're right there. I mean, not that, you know, not that they don't using other platforms, and there are, of course, now a number of other platforms there, but it's just so important to have that emotion be able to come across. And if someone wants to cry, they can cry, you know, or you can have an apology if that's what somebody wanted to do, you know, and have it appear meaningful and be meaningful.
It's a really interesting point you make, because some of the judges we've worked with have said that far from being an inhibitor, they find the video is actually an enabler of their ability to read the expressions of the people, to assess their veracity and their credibility, because they're right up close. And it's really interesting because I think at the beginning of the pandemic, everybody thought, oh, well, you'd never use this in cross-examination. But in fact, it's the opposite. And to your point about, you know, people feeling that they can cry or they can apologize, our experience has been that some very vulnerable participants, it's better for them to be on video, particularly in the family domestic violence space. And we built some features that enable the mediator, for example, to shut down audio, video, and even chat between the mother and father, or the husband and wife, because we were told by the family court in Australia that sometimes the vulnerable women are really impacted by what goes on underneath. So, you know, there could be abusive chat going on between the mother and father, and you may not know about that, or they might be showing imagery that is inappropriate. And so we built a lot of tools to enable a mediator to kind of immediately shut down abusive behaviour. And so all those kind of things lend themselves, I think, to new applications in ways that we only dreamt of, really, in the physical world. So hopefully it's not just something that we have to do because we can no longer travel, but it actually makes the experience overall better, not just more efficient. I mean, the efficiency gains are obvious, but it's what is the experience that we're trying to replicate is the hard part. Everyone knows it's better, cheaper, faster, but is it experience? And they're the things that I think the people passionate about mediation are always going to want to try to ensure.
I think your vision has been fantastic, and you've done a great job of bringing it to reality and having it be something that people around the world are using now and can use. And it's not, to me, it's not just a temporary substitute for in-person. It's a long-term way of doing things and building it all in together into, you know, one function, if you will.
Well, and back to the point about the environment, I mean, one of the things that I feel is a legacy that I'm quite proud of is stopping people flying around the world to do dispute resolution. And the more we can enable that, the better. We've had matters in recent times between parties in Texas, Australia and New Zealand. And I mean, ordinarily the cost, the financial burden, but also the environmental burden of that taking place in person, which it regularly did, we all know, was astronomical. And so we've joined the Campaign for Greener Arbitrations as well to try to provide technology that can actually facilitate green mediation and green arbitration and make it a long-term solution, because we don't want this, the silver lining of the pandemic to sort of be taken away once it's over, which I don't think it will be now. I think the benefits are so obvious to so many of us that it's here to stay. And what we need to do is make the solutions really good for the long term.
Right. You say that. I had a case once when I was in practice, and it involved a winery from Australia and a packaging company from the US, and losses that were in Europe and Australia and all around. And, they were doing the depositions in Australia. And so the partner who was working with me on the case, he took the depositions, and he was up in the middle of the night, I think it was, on the phone. He didn't have the video to be able to do that. And that was not that long ago. But instead of traveling, unfortunately, didn't travel on that one, but for the experience, unfortunately, but not for the cost, obviously. It was telephonic. So what a difference now something like this makes to be able to be, live, so to speak.
Oh, absolutely. And I think what it does for mediators is opens up a world of practice that maybe they didn't have before, that they can take those really interesting cases. Natalie, you're probably experiencing this, that the geographic boundaries have disappeared. And so people's expertise can be shared much more broadly than perhaps what it was 2 years ago, which is exciting. And in Australia as well, we've always had the travel barrier, which has meant that we can't really get much above Asia very quickly. So it's really great to think that very highly qualified Australian and New Zealand mediators and arbitrators can be more involved in some of the international work.
I think that's absolutely true for all of us. I think that there's no going back now. We have opened up an entirely new world for the resolution industry, but it's not just in these platforms. It's also in the expectations placed on our industry. And so, our clients and parties now, they fully expect and should be given the opportunity to calendar something online, or to have follow-up, like with programs like Our Family Wizard,
Yes.
Where both parents can download the application on their phones or their iPads or their computers, so that if, exchanges with their children are maybe not the best situation, they can share immunization records, they can share the schedule for volleyball games, they can share parenting plans, they can share, prescriptions, they can share all of that information using technology so that their ongoing family plan runs more smoothly. They expect that from us, and we should be able to give that to them. Our clients being able to use Acuity scheduling or Calendly or Google Chat or all of these programs, I think simply is the way that we have to now provide as business people. We have to provide that service to our clients and to their parties. And I think that all of these little things that we can add to make the experience better for them, easier for them, help them find that reasonable, durable solution to whatever it is that's keeping them awake at night. All of those things make a big difference to somebody else. And for geeks like you and me and Jean, they're kind of fun. We actually really enjoy, clicking on all the buttons, but our clients really do deserve it from us. And they could be little things. So, for example, if someone is in the middle of a mediation using your platform, Immediation, they could, put things on pause and click over to a negotiation software platform like Wrinkle. and put in, you know, this is my number and this is, you know, the other party's number, and it gives you the score about how far apart you are in this negotiation. Then they can come back into your rooms and, you know, continue on with the negotiation and keep things moving. And you could do that as the mediator. You could do that as parties. You could do that as, you know, the representatives. But all of these tools that we have now at our disposal really, I think, make our industry so much stronger.
It's really interesting you say that, because we actually just built that so that we could have it within the platform as well, that sort of tool that brings people closer together and enables asynchronous negotiation, both asynchronous for its own sake, but also to support mediation. Because I think if you can get rid of that shuttle bit at the end, which, you know, which takes forever and is so cost ineffective, to be sitting there for hours waiting for, you know, $5,000 bids backwards and forwards. Seriously, a waste of time. But you're right. I mean, the industry deserves as well. I think mediators deserve the best tools at their disposals, because they do a really hard job, and it's often a thankless job. It's one of these things, I think, that supports the entire legal industry, but it's almost like the emergency workers, where, you know, the resolution industry workers are there doing this thing to support the legal industry, which it would all fall apart if we weren't there as mediators, because how would you ever get the caseload through the system? But sometimes, you know, the mediators need a bit of help on their own as well, or their own support. And so the more that we can build tools, as you say, Jean, that support this very important industry, the better, because it keeps us all afloat as barristers and counsel as well.
Could you just tell us about the arbitration? That's of interest to me for arbitrators, because you've got the configuration for the judiciary and also for conducting arbitrations, so that it's different. It's not just taking a mediation platform and applying it to an arbitration. Just a minute or two, maybe you could discuss that. We have arbitrators that are in our audience from around the world.
Yeah, so I mean, I guess there are different tools that you bring to bear in a mediation or an arbitration from a technical perspective. A lot of them are very similar, because what's going on in the person's head is not necessarily the point, but we do things like, for example, you can do your orders for your preliminary conference or your first set of orders on the platform and co-draft them with the barristers or the counsel, depending on where you are in the world, and everyone can see. And so that can be then done and signed. We have a program where, you know, for the intake part, the arbitration agreement and the rules and all of that can be agreed and uploaded in advance. And then, you know, your pleadings can be stepped through a process to streamline that part from an arbitration authority's perspective. So to your point earlier, it's both the back end part and also the front end part, and then also helping the arbitrators in the room manage complex scenarios. So the way our platform works, I guess, it's been designed for the more complex end, where you've got multiple arbitrators, multiple mediators, and loads of different parties. And so we tend to shine, I think, our brightest light in that kind of environment where it's really hard to take a standard video conference and adapt it to that environment. But with our ability to handle multiple clients on multiple sides and do all the drafting as well, it sort of takes the pain out of that part of the equation. So it's not so different for mediation and arbitration, but there are some specialized tools that we do use. And one more that we built that's worth noting is live stream. So we built the ability for judges or arbitrators to control a live stream of their case to a private link. And what that does is enable you to keep out of the video conference all the hangers-on and onlookers in a large arbitration. You know, you've got 3 or 4 global law firms and hundreds of interested people, and you actually, as an arbitrator, don't really want them there in the room, but they want to see what's going on. So we can live stream that to the people who are interested and make life easier.
That's fascinating. Yeah.
So that brings up something I'm curious about. one of the questions we get, I think, frequently in use of these kinds of technologies, Zoom or Blue Jeans or Immediation or any of the others, is how do we manage a situation that needs to be a hybrid between in-person and online? And so what are our options when someone says, well, this technology thing, it's just not for me. I don't want it. I don't like it. I don't own a computer. I don't have Wi-Fi, whatever their situation is. How should we, or how can we create an appropriate environment so that it's partially in person or partially online?
We've done all of those. So we've had experiences where, for example, in that one I just referenced, all of the Kiwis were together in Auckland, and I don't believe the Australians were, because they were in lockdown in the different jurisdictions. And then we had the Texan party. So I think that you can manage it by having people gather around a screen. We've even gone so far as to have physical replication by different computers of the private rooms that we have. So they're sort of picking up the computer and walking into a different room in the mediation suite with it, whilst our host is actually moving the people who are online into their own private room. So you can do those kinds of things. I mean, the ideal, I think, is that the platform enables the requisite type of communication, whether that's plenary session or caucus, with everyone on their individual device, because that way they get the best experience of all of the tools available to them. But in the event that we need to do that, I think you just need to use novel things like that to sort of say, well, we need to make sure the people online are included, and we need to make sure the people offline are included, but that they somehow merge together. And in that situation, it really is best, I think, to have a host who can sort of help run the whole thing to make it a smooth experience, because my view is to attempt to do that as a mediator or an arbitrator, as well as do the mediation or arbitration, means that you're not doing your best work, because you're focused on where's everyone going and what are they doing and can they get in. And by the way, have I lost that group who've just gone off randomly, rather than focusing on the job? So we try to supplement that by providing help. I don't think it's fair. You didn't go to law school or resolution school to be an IT person. You went to law school to be a lawyer. We try to take that away. Well, they shouldn't be, really. I mean, we try to make the technology support, not inhibit, because that's the whole point, is it's meant to enable.
That's great.
So, and the same technologies we're seeing being used in municipalities. We're seeing them used in court systems. We're seeing them really being embraced in, private panel work. So I know that there are a couple of private panel organizations that have created their own kind of platform, so that all of these needs of all of these different people get met. I think it's absolutely brilliant.
I think so too. And it's amazing how in such a short space of time, being required to do it has meant that acceptance has come. And God only knows how long it would have taken just sort of naturally to get to this point. I think I saw an article saying it's 10 years of technology adoption in 6 months of last year. But we all know with this industry being very traditional and quite conservative, which is natural, that it would have probably taken a very long time. So I think it is a silver lining of the pandemic, and great for women too, while we're on the point, that they can work from home and look after their children and do all the things, as well as take on more work at times that suit them. So I think there's more than one silver lining to all of this.
Right. Yeah. The last month's American Bar Association published an article about the impact that COVID has had on women, and we have had to take on the bulk of the weight of staying at home with children. We've had to take, I think it was 60% of female lawyers, mediators, and arbitrators had to sacrifice their livelihood, their everything, to be able to cope with the situation, which is an enormous burden for women to place. But we're talking to, you know, an award-winning woman entrepreneur. Really impressive work that really impressive work that you've done, Laura. Thank you so much for your efforts.
Thank you so much. It's lovely to speak with you. And again, thank you for having me on the program. And I think that the food bank initiative that you have is unbelievable. I've been telling everybody about it. So thank you for that opportunity to participate in that as well.
Sure. Do you want to get in one more plug for your preferred food bank before we?
Yes, Second Bite Down Under. And it would be great if you could support it. Thank you so much.
Yeah, Second Bite, and we'll put the link in for everybody so that they can click and hopefully make a donation.
And thank you so much. It's been a pleasure getting to know you, and look forward to interacting on other things in the future. Thank you.
Thank you so much, Jean.
Thank you.
Thank you.
Thanks, everybody.